Good afternoon, everybody, and I call the House Judiciary Committee to order. This is our sixth meeting of the interim. Clerk, please call the roll.
Representative Manta.
Here.
Representative Blanton. Here. Representative Bratcher.
Here.
Representative Bray. Representative Burke.
Here.
Representative Dietz.
Here.
Representative Doan.
Present.
Representative Flannery.
Yes. Or here.
Representative Herron. Representative Colcarney.
Present.
Representative Lewis. Representative Maddox.
Here.
Representative Mosier.
Here.
Representative Nemus.
Here.
Representative Petrie. Representative Rawlings.
Here.
Representative Sharp.
Present.
Representative Stevenson. Present. Representative Wilson.
Here.
Vice Chair Decker. Chairman Elliott.
So we have a full agenda today, 9 bills, an ambitious agenda, so welcome, and we're glad you're here. The first bill we are going to hear is Senate Bill 203. President Robert Stivers, if you'd come forward and introduce yourself, and there's a committee sub, is that right? And there is a committee sub.
Yes, sir.
Senator.
Thank you, Mr. Chairman. I'm Robert Stivers, the State Senator for the 25th Senate District, and also the President of the Senate, and I appreciate you allowing me to come before you in this committee.
Is there a motion to adopt the sub? There's a motion and a second. All in favor, please say aye. Aye. Those opposed, no, and the sub is adopted. You may proceed, Senator.
Thank you, Mr. Chairman, members of the committee. I hope to be fairly brief. After 27 years of being here, you don't have a lot of practice of law left, but this is actually one area I still do some practice in. And what I have found is where you have a client that is more in the vein of a corporate client, that they will have individuals when a therapist or one of their employees gets subpoenaed and asked to deliver records, that they will naturally get a protective order in compliance with what everybody knows is HIPAA. And so I generally go in, even though it is not my client that are involved in the hearings. My client is part of the testimony and production of documents and witness in the respective hearing, wherever it may be, versus a juvenile matter. Can be in criminal matters, generally in domestic matters. And we'll get a protective order that sets out what documents are to be delivered, what can be testified to, and then at the conclusion of the hearing, what are to be done with those records, be it medical in the sense of what we call traditional medical records, or what other people think of totality of medical records when it gets into psychological records. Well, that's what generally happens, where you would say, and I'll use for this instance the University of Kentucky that has corporate counsel that looks at the subpoena that's served on them. What happens in many occasions when there is not someone like that, and you have in a divorce action or in a child custody action, that a subpoena is served on a practitioner, a provider, that does not have counsel for them, and they will show up with their records. And then those records, not having something in Kentucky statute, but this is all reflective of federal statute in the CFR, there is not a clear order setting out what should happen to those records at the conclusion of the case. So this basically parallels 203, and the committee sub was to create some technical corrections. 203 basically parallels HIPAA to say at the closure of the case, those records are to either be destroyed, returned, or sealed in essence, and not disseminated beyond the parties or the necessary people needed to testify. But everyone would be under that order.
Motion on the committee sub. Second.
Motion by Representative Nemus, a second by Representative Blanton. I'm sorry.
I've learned to be quiet if you get a motion.
Right, motion. I think your motion was on the bill as the substitute on the bill. Is that right? And so
Have we adopted the committee sub? Okay,
We have.
Yeah, motion on the bill as adopted by,
Yes.
amended by the committee
And
sub.
so is there any discussion amongst the committee? Representative Dietz.
Yes, thank you.
Yes, ma'am.
I am a family law practitioner, so I looked at it through that lens. And I have a question regarding, it says, include other measures as are necessary to limit disclosure for the protection of the patient, the physician-patient relationship, and treatment services, and it says such as. And it says restricting the discussion of the content of the mental health records with anyone who is not a party in the case. So my concern is about a guardian ad litem, a friend of court, custody evaluator, a parenting coordinator, and thought maybe you could shed some light on that for me and that concern, because those would be people that would have to have access in a child custody case to make recommendations.
As to a guardian ad litem, I would assume that would be considered either a party or kind of a quasi-party, because I could see a guardian ad litem being appointed in a divorce case, actually, for a ward of the state. Because if they are a ward of the state and you start proceedings, divorce proceedings, while your spouse is in there, I think a guardian ad litem could be appointed in that situation. I'm not sure how far that could go, and to be quite honest with you, it's been years since I've practiced domestic law. As to that, I understand your concerns about the mental health and medical records with other parties. It may not be clear, but if you wanted, and I think I understand where you're going, but to assume anything around here is always a dangerous thing, that if I subpoenaed records, psychological records, and wanted my expert to look at them, that expert would have to have access to evaluate them to say, are these accurate? And then are they even relevant too? So I think you're wanting to make sure that in those situations, individuals who are necessary to testify would have access. I don't disagree with you, and if that language needs to be clarified, I understand that. The key thing, though, is they don't get distributed outside of the action once the action is complete among those parties, and that you don't wind up on Facebook with a disgruntled party that's putting out your medical records. And that's what we're trying to protect here. If I assumed what you're talking about is accurate.
May I?
Yes, follow up.
Yes, it absolutely is. So my concern was just making sure that in child custody cases that we were still able to give those records to those people so they could make their reports, and I'd be happy to work on any language to tighten that up. But
If you have some, I don't have a problem, and I'm going to talk about the individual that would be getting records. When I did practice, we used a man named Dr. Feinberg in Lexington that did the family evaluation, and all parties were required to appear before him for some type of assessment or viewing. Mm-hmm. Again, it's been years, but that would be an individual you think you would want to have certain records, because anybody that is a significant other then becomes questionable in the fact of a custodial type of hearing, and those people that surround each party, I think, become relevant to the action.
thank you.
Yes, ma'am.
Representative Burke, you're recognized.
Thank you, Chair. May I ask a question?
Yes, you may.
Thank you. Mr. President, thank you for this bill, and thank you for coming to share with us what I now understand is the principal purpose, which is to prevent unwarranted disclosures of private medical information by a disgruntled co-party after the case. With that motivation in mind, as a family law practitioner, in addition to Representative Dietz, I'm coming at this from a very practical perspective. My first question is, are the records going to be tendered, provided that they're needed, they're found to be relevant, the judge has ordered that they're to be produced, are they going to the judge's office first? Or are they coming to council? Where are they going? It was not clear to me.
Generally, if there is a subpoena, and there are two things I think you have to look at in these, is one, the testimony of the provider and the records of the provider Records, as I generally do it in my understanding of HIPAA, I produce them to the court for the court to review and then determine who gets the dissemination of the records. And I have my orders prepared that way. And then there naturally, if one party or the other wants to object, then you get into a total different type of hearing as to relevance. But it would be the judge's decision upon what is relevant or not. And to me, that is not what I am worried about, because that's going to be, there could be all types of records out there that are pertinent and not pertinent, relevant or not relevant. And that will have to be a judicial hearing. You get it sealed, you can take it up on appeal, any type of abuse of discretion, type of arguments you want to make. The key thing is at the end, that those records stay within a very narrow group, if not sealed or destroyed, and they are not disseminated.
And I appreciate your response. May I ask another question?
Yes, you may.
Thank you. With that in mind, it seems to me two things. First, that it's going to impose a really intense burden upon the judges in family court, who already have some of the fullest dockets anywhere in the state. Family law cases are the most commonly filed types of cases. Those judges are quite busy. To ask them to make preliminary findings before records are even released is going to slow down the pace of family cases, and most concerningly, it could leave children in places where they don't need to be as we wait for a determination of whether or not we should receive records that are included in 403-270 as being initially relevant. So I have concerns about the pace of family court and slowing it down to the detriment of the well-being of children. My second concern relates to how we're going to get them to these relevant professionals. Do the relevant professionals then need to come to chambers in order to review documents? Are we going to ask Dr. Feinberg to make a special trip? Are we communicating using confidential email where there are passwords? And then a final concern, and I hope you can address all three for me. In Fayette County, we e-file all family law cases. It's the rule of our circuit that you e-file. And it seems to me that that's going to be quite unworkable if every case with mental health records becomes sealed. Can you speak to those three concerns for me, please?
I wish I'd brought my pen to make notes. First of all, let me say this. This is federal law already. This is just mirroring federal law, putting it in state statute, because the judge is required to make these determinations as it is under HIPAA. What it is not contained in is within our statutes, and a lot of people, seriously, I didn't think about this till somebody came to me, and it was actually another Fayette County practitioner who told me that this was going on, and relevance is always going to be a judicial proceeding. My medical records as to my broken leg are one thing. My medical records as to my psychological background are totally different. What is the relevance to the case? Is it a car wreck or is it a custody case? And so you can distinguish which one is relevant to which. That is always going to be up to the judge, and that is what happens, to my knowledge, and again in practice, with every record that is put up there, and somebody can challenge it. It may not be challenged. Courts are going to have to hear it, because there's going to be some type of protective order or motion in limine as to what goes before the trier and finder of fact. So it may slow down the process, but it is actually federal law now. We are just basically codifying that in state law. Any other questions along that line? And how you disseminate it, I think, was the other one. That is one, again, we can always think of things, yes, you want to be quick and review, but if you think about that, by the time you get a subpoena prepared, you deliver it on a provider, and then the provider comes to deliver, it's probably going to be several days in essence. I'm not sure unless there's some type of emergency order, emergency hearing, to obtain or acquire those records, there's always potential for time lag in any proceeding.
Thank you for your answers. I remain concerned that this is an unworkable set of red tape that is unnecessary to achieve the outcome you have stated, which is to protect people's medical records. I feel that the judges still have contempt power and could absolutely sanction or punish any party who would unlawfully distribute someone else's medical records as a threat or a punishment to them if they don't like the way their family law case is turning out. And my number one concern is the well-being of children. And I shudder to think that in order to prevent future disclosure of someone's psychological records, that we would leave children in dangerous circumstances to wait for these additional procedures to be done. Thank you.
Thank you, Representative Dietz. Quickly for a follow-up.
This is more of a comment. I think where our concerns are coming for, and I don't have the custody statute, mental health is already a consideration of what the judges have to consider. So when we already have that in our statute, that's something they have to look at. So our concern then is how do you get the relevant information then to these other parties and understand completely the purpose of this now. So I appreciate those comments. So I'll be a yes vote today and just hope that we can tighten that up so that we protect the guardian ad litem, friend of courts, the other significant players in family court, given what the statute already calls for. Thank you.
Thank you. So there's a motion and a. Did you want to comment further?
And
I'm
under
sorry.
no way, if it is relevant to the trying of the case, whatever it may be, because it may not necessarily be a custody case or a divorce case. It could be in other situations. Dissemination to the appropriate parties to make evaluations of their case is not the intent of what this is trying to do, to keep someone from having additional hoops. It is on the back side of it to protect those individuals from having dissemination. And if I can, to Representative Burke, it's hard to unring the bell and stop the damage when, in the couple of cases I was involved in and brought into, where a young lady's records were put on Facebook. A fine doesn't quite deal with that. Contempt sanctions don't quite deal with that.
So would our secretary please call the roll?
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Brasher,
Yes.
Representative Bray, Representative Burke,
No.
Representative Decker, Representative Dietz,
Yes.
Representative Doan,
Aye.
Representative Flannery,
Aye.
Representative Herron,
Pass.
Representative Kulkarni,
Yes.
Representative Lewis, Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson, Chairman Elliott,
Aye. So with 14 yes votes, 1 no vote, 2 pass votes, Senate Bill 203 with House Committee substitute is passed and will be reported with favorable expression that the same should pass. So congratulations and thank you, Mr. President. There is a title amendment. Is there a motion to adopt the title amendment? Motion by Representative Doan, second by Representative Blanton. All those in favor, aye. Aye. Those opposed, no. And the title amendment is adopted.
Thank you,
Thank
Mr.
you,
Chairman,
sir.
members of the committee.
So next we will hear House Bill 204, Representative Steve Rawlings, an act relating to restoring religious liberty. And I know he has some online guests, so we will accommodate them. And there's also a committee substitute. It is in your folder and was emailed last evening. There's a motion, I think. Representative Wilson, second by Representative Doan. All those in favor, aye. Aye. Those opposed, no. And the amendment, or the substitute, is adopted. And you may proceed, Representative Rawlings, and introduce yourself.
Thank you,
and
Chairman
your
Elliott.
guests.
Yes, I'm Steve Rawlings. I'm State Representative for District 66. Our guest is Greg Chaffwin with Alliance Defending Freedom. Is it appropriate for him to introduce
Yes,
himself?
that's fine. I think we're trying to get the Zoom on.
Hi, my name is Greg Chaffwin with Alliance Defending Freedom. I'm an attorney here.
You can proceed. Thank you.
All right, thank you. I'm here today to present House Committee Substitute to HB 204. The measure seeks to update the Religious Freedom Act and ensure that Kentuckians are free to live and work according to their faith, without fear of being unjustly punished by their government. Our act is the shortest of 23 states that have one, and right now it does not have any definitions. The brevity of the current statute gives courts, not the people elected to make laws, the flexibility to undermine the religious freedom of Kentuckians. Definitions provided with this bill will help ensure that religious Kentuckians can rely on the act to be heard in court. They can also give the courts clarity in how they should weigh these rights against the state's interest in burdening them. Kentucky's Religious Freedom Act is 10 years old. Since its enactment, courts across the nation and the Supreme Court have developed the meaning of terms found in similar laws on the books in other states. Some courts interpret their state's religious freedom language so narrowly that they refuse to hear certain religious claims. Other courts have taken more expansive approaches to these laws. HB 204 codifies definitions that are the most protective of religious freedom, relying on what is working in other states and the results of court cases. Ultimately, this bill seeks to ensure that religious rights are adequately protected. HB 204 ensures that Kentucky courts will use the most accommodating language to ensure that religious Kentuckians have a fair day in court. Codifying these definitions will ensure that Kentuckians can be heard if any part of the government burdens their religious practices. HB 204 does not create new rights. Instead, it codifies the judicial standard that determines how seriously we take our commitment to religious freedom in the Commonwealth. Religious people and houses of worship are facing more and more government intrusion and violations of their right to freely live and freely worship. We must ensure that our Commonwealth has the strongest Religious Freedom Act before these trends worsen. Mr. Chairman, may my guest speak at this time?
Yes, go ahead.
Well, thank you very much. So as part of my role here, I review religious liberty legislation across the country, and I provide legal analysis on how they'll impact religious freedom rights. And I would echo everything that has just been said. It's true that Kentucky law currently requires strict scrutiny for state action that would substantially burden religious freedom rights. But as you have the shortest of the RFRAs that are across the 23 states that have them, that does give this leeway to judges that might narrowly interpret the laws, and that could leave people without relief for their religious freedom rights. Just two things to note about the language used in this bill. It uses definition for government that's very similar to what Montana passed just 2 years ago. And it's also similar to what's used by most of the states that have RFRAs. And the definition of substantially burden is also the same as what Montana used. And very similar language is also used in other states like Kansas and Louisiana. And so towards the end of the bill, it also ensures that people can seek appropriate remedies when their rights are violated under the act. There was a recent case in Kentucky that noted that the current RFRA does not waive sovereign immunity, which means that there are certain reliefs that will be unavailable when the act violates a person's religious liberty rights. And that's unlike the Civil Rights Act, which does include such a waiver. And as religious freedom is, of course, the first of our civil rights, I think it's appropriate that this includes that. So these definitions provide the meaningful direction to judges who need to apply the law to a wide variety of factual scenarios, and ensures that citizens have this clarity about their religious freedom rights, which also ensures that they can stand up for their rights instead of possibly being warned by an attorney or someone that Kentucky's RFRA might not apply to them. So just to close here, the bill strengthens religious liberty rights in Kentucky by ensuring that courts today and well into the future will continue to apply the law as intended. and ensuring that everybody can have a fair hearing in court if the state stops them from practicing their religion. And I'm available for any questions if anybody might have them.
Thank
Move
you very
passage.
much. There's a motion by Representative Bratcher on the committee substitute. Is there a second? Okay. Oh, we have, okay. So this is a motion on the bill by Representative Bratcher. Is there a second to Representative Doan? Is there any discussion? Representative Burke.
Thank you. And this question might be best suited to our guest. I'm not sure. Whichever one of you wishes to answer. Will the standard used still be strict scrutiny, or is that different now with this bill?
Our guest can answer.
Yes, strict scrutiny is still the same standard. That's in the substantive provision in section 2. That remains unchanged.
Thank you.
Representative Herron.
Yes, thank you. I just have a question about, there's a part that talks about the protections afforded under this section shall not apply to an inmate in the custody of a jail or local or state correctional or detention facility. I just want to get more clarity on why that is in there and needed, and then also, is that the only change in this committee sub?
It is the only change. We had a request from a Kenton County prosecutor that didn't want to have civil actions filed against him or law enforcement or judges from inmates. So that was his request, and that is the purpose of the committee substitute. So that is the one exception is inmates.
And if I may,
Go ahead.
the federal law also, it's called RLUIPA, Religious Land Use and Institutionalized Persons Act. That already covers institutionalized persons, inmates, and prisoners. That's federal law. That has been the case for more than 20 years now, and that will remain the case.
Representative Stevenson. Yes.
Thank you. Two questions. In paragraph 4, it says that any infringement that happens before or after the effective date of this act, the people will have these remedies. So you can go back and say the government did something to stop you from praying that happened 2 years ago, and it would be covered under this act?
I'm sorry, you mentioned paragraph 4. Is that, I don't see that. Is that the committee substitute? Where is that?
Okay, I got the wrong paragraph. I'm speaking from the original, where it says that no matter what the law is or when it was, whether it happened earlier or after the statute is enacted, that they have remedies under this statute. Is that correct?
So
Yeah, go. I'd like the guest to answer that, please.
it's whether or not the ordinance, so that it's, one question is when was the law passed, and the other is when is the state action. So laws passed in the past, if they're applied in a way that substantially burdens religious exercise, we look at when is the burden, and that's what would be applied. But this just says that religious liberty is protected from the application of laws from all of the laws. It's similar to what all the other states that have RFRAs do. It says any state law that's used to address to substantially burden religious exercise should not be done so.
So you can go back in the past.
Well, right, but you would need to look at when is the act that is burdening religion.
Okay, thank you. And then the second question is,
Yes.
if a church is in the pathway of a tornado and the government says you guys need to move out, does that stop them from protecting the community?
Would you like to also answer that, guest?
Public health and safety is a common compelling interest that courts recognize.
Okay, thank you.
Thank you, Representative Moser.
Thank you, Mr. Chair, and thank you for bringing this. I think this is a really good discussion, but I do have a question on line 14 of page 1 of the committee sub. It says compels any action contrary to a person's exercise of religion. Will this include a conscientious objection on the part of a healthcare worker to allow for a denial of care?
No, there's things in the law that protect emergency care must be provided at any time for any service. So emergency care is covered. Would our guest would like to answer that one also?
Well, that's right. EMTALA already covers that from a federal perspective, but compulsion of speech, compulsion of action is something that's regularly ensured is protected as a fundamental right. And remember, what the current strict scrutiny test does in Kentucky, and this doesn't change that, is that it doesn't decide outcomes for these cases. It would say that a person can bring a case to a court, and the court will weigh the state's interest in compelling, for example, compelling a person to do something that might violate their religion against the compelling state interest and ensuring that people get the care they need and whatnot, and also if that's the least restrictive means, as Kentucky's law currently states, is accommodating religious practices where feasible.
Okay, thank you.
Thank you. Would our secretary please call the roll?
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Bray, Representative Burke,
Yes.
Representative Decker, Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery,
Yes.
Representative Herron,
No.
Representative Cole Carney,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson, Chairman Elliott,
Aye. So with 16 yes votes, 2 no votes, and 0 pass votes, House Bill 204 with the House Committee substitute is passed and will be reported with favorable expression. Congratulations.
Thank you.
Representative
Thank you for
Rawlings.
the honor of presenting this bill to the committee, and thank you for our guest for appearing today.
Thank you. Thank you. Senate Bill 40 will be next on the agenda. Senator Philip, if I can talk today, Philip Wheeler is recognized. An act relating to genetic testing in death investigations. So if you'd introduce yourself and you may
Thank you,
proceed.
Mr. Chairman and members of the committee. Philip Wheeler, 31st Senate District. Some of you all were here last year may have seen this bill. It's the Micah Chantel Fletcher bill. This bill, to give you the 2-minute version, Chantel was a young lady visiting U Pike's campus for a site visit. She was found deceased at the bottom of steps of a dormitory without a mark on her. Law enforcement investigation was opened. They sent the body to Frankfurt to see what could happen and why she may have died, and the cause of death came back undetermined. Due to the persistence of Chantel's mother and a local detective, Bruce Collins, they weren't satisfied with undetermined. One reason that law enforcement is required to open a criminal investigation in undetermined deaths. But they found a geneticist at UVA who was able to take some fluids and determine that Micah Chantel suffered from a genetic heart defect that actually could have been treated with a simple beta blocker. And because of that, the rest of the family was able to be tested and to determine whether or not they also suffer from this genetic heart abnormality so that they could get the appropriate treatment to keep them from passing away. This bill would require limited genetic testing for cardiac abnormalities for persons whose cause of death is found to be undetermined, who are under 40 years of age. It started out as a slightly broader bill, but due to some limited resources at the medical examiners and working with the coroners, we dialed it back to this group of folks who make up the vast majority of undetermined deaths in the Commonwealth of Kentucky. I like to say this bill is as much about life as it is about death, in the sense that it allows people who may suffer from congenital abnormalities to potentially get treatment when someone dies from one of these things.
There's a motion by Representative Blanton, second by Representative Banta. Is there any discussion? If not, okay, I thought Teresa. Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Bray,
Yes.
Representative Burke,
Yes.
Representative Decker, Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery,
Yes.
Representative Herron. Yes. Representative Polkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox. Yes. Representative Mosher, Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson. Yes. Representative Wilson. Yes. Chairman Elliott.
Aye. So with 18 yes votes, no votes, and no pass votes, Senate Bill 40 is reported with favorable expression that the same should pass. So
Thank you, Mr.
congratulations,
Chairman.
Senator.
Yeah.
Thank you for bringing this bill. I'm going to take next Senate Bill 199, which is Senator Rick Girdler, an act relating to crimes and punishments. Is there? Good to see you, Senator. If
Thank
you
you.
introduce yourself and your guests, and
My long
you may
lost,
proceed.
my long lost representative.
I know. Turn your mic on. I miss.
Oh, all right.
I miss being in your district.
I-
So
I
that
miss you.
happens sometimes, doesn't it?
I brought my attorney with me also, and then I've got my good buddy Josh Bray, which took your place. Senate Bill 199 is basically a tracking device that people have used illegally, or to check on maybe an ex-wife, or maybe somebody they've had trouble with, or maybe they're stalking. And all we're trying to do is make them illegal. And basically, it prohibits someone to have ordered to stay away from an individual from tracking the protected individual's locations, say they want to find out where they're at, or it prohibits someone on probation or parole from tracking if it's a crime in the family or a member of the victim. Now, we do have a sub.
Do you have a committee substitute?
Yes.
Is there a motion to adopt the committee sub? Representative Banta with the motion. Is there a second? Second by Representative Nemus. This committee's ready to go, Senator, as you can tell. And all those in favor, please say aye. And those opposed, no, and the sub is adopted. Okay, well, apparently I don't know. So I'm going to determine that it is adopted. So you may proceed to explain.
The bill, and I'll let Representative Bray explain the other. The bill itself, it don't prohibit the things that's in our car already, the GPSs, the things that are built into the car that tells them where I'm at or anything else about it. It does prohibit somebody sticking a device on your car to find out where you are. And that's basically against the law. And Senator Westerfield, which is our geek buddy, and our attorney over there, liked the bill, and I liked it as well. Now, I've got a committee sub that I agreed to put on, and I do like the committee sub as well, so I'll let him explain that.
You may proceed, and I'm sure we'll have some discussion about that.
So, in House Bill 157 last year, it was the DUI fix bill. There was a requirement that hospitals withdraw blood from a defendant if there was a court order present. If the court had ordered them to draw blood, they were required to do it. There has been some liability issues raised with that. Hospitals are concerned with that. In one case, a hospital has refused to do that because generally they require consent to have blood drawn. And so all this does is it just fixes that. It provides that they, if they are required to do that, it gives them some protection. That's it.
Representative Flannery, you're recognized.
Yes, comment and question. Senator Girdler, I'm not opposed to your bill as it came over here. I am opposed to the committee sub. Question for for Representative Bray. I was the sponsor of House Bill 154 last year, and what 154 changed was the fact that under the old law, there had to be the showing of a death or physical injury for a blood draw. What 154 changed is it allowed it for any circumstance in a DUI based upon that Supreme Court case, and tried to address that. Help me understand what the liability issues are for a hospital, because previously there were multiple situations where a party would not consent, but there would be a warrant, judicial authority for that blood draw. So I don't see really why this would be necessary.
Absolutely. So hospitals are trained that their employees have to give consent. I mean, if you're going to perform a procedure on someone, you have to have consent. Attorneys from hospitals, my hospital, has raised issue with this, saying they don't feel comfortable if a person does not consent, but there is a court order that says you shall. I mean, that's the heart of the issue. It just clears that up.
All right, so there is a court order with that warrant. So how would that be any different than a subpoena or any other, I guess, judicially authorized documents sent to that organization?
Like I said, this just provides them protection in the event that someone does not consent.
Is there any other discussion? Seeing none, we have a motion and a second, so would our second... Okay, so we do need a motion on the bill, a motion by Representative Nemus, a second by Representative Moser. And would our secretary please call the roll?
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
I'm going to vote yes to keep it going, but I'm still a little bit confused on what the discussion was, so we'll move forward.
Representative Bray,
Yes.
Representative Burke,
I'd like to explain my vote.
Yes, you may.
Thank you. I am a yes. I would prefer to see these as two separate bills, since they don't appear to be on the same topic. Thank you.
Representative Decker, Representative Dietz,
Yes.
Representative Doan,
Pass.
Representative Flannery,
Explain my no vote.
Yes, you may.
I'm for 199. As it came to committee, would I guess agree with Representative Burke on this. I think these two should be two separate issues. No offense to Representative Bray, I know he's had a lot going on, and we can talk about this issue, but I just think these should be two separate issues, and really have a personal problem with how some of this was handled earlier in the session on this committee sub. So for those reasons, I'm going to vote no on this.
Representative Herron,
No.
Representative Kulkarni,
Briefly explain. I'll be a no
Yes.
today because of all the issues. Sorry, Chairman. Thank
Yeah,
you.
go ahead.
Because of all the issues that were raised today. And hopefully this will get resolved before it comes to the floor. Thank you.
Representative Lewis,
Yes.
Representative Maddox,
Mr. Chairman, may I explain my vote?
Yes, you may.
Senator Girdler, I like your bill. I have an issue with the committee sub. I am going to vote yes today, but I will vote no on the floor if the sub isn't addressed. But I appreciate your bill, Senator Girdler. Thank you.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson, Representative Elliott,
Aye. So with 14 yes votes, 3 no votes, and 1 pass vote. 4 no votes. There's 4, okay. Correction, so 4 no votes, 1 pass vote. Senate Bill 199 with the House Committee substitute is passed and will be reported with favorable expression that same should pass. Thank you, Senator, and thank you, gentlemen.
Chairman. Thank you.
Let's see. We will next take up House Bill 535, Representative Dietz, which is an act relating to criminal justice data and making an appropriation therefore. Oh, is he here? Thank you. And you may introduce yourselves, and then we'll take up there is a committee sub.
Thank you. I'm Stephanie Dietz, State Representative from the 65th District, which is a part of Kenton County. So I'll let my guests introduce themselves.
I'm Olivia Spradlin with the Kentucky Coalition Against Domestic Violence.
I'm Natalie Barikinoff. I'm with the Justice and Public Safety Cabinet.
Elsie Berger. I'm with the Criminal Justice Statistical Analysis Center with the Justice and Public Safety Cabinet.
I'm sorry, we couldn't hear you, sir. So if you could.
Elsie Berger. Sorry. Elsie Berger with the Criminal Justice and Statistical Analysis Center and the Justice Cabinet.
Thank you. Thank you. So there's a committee sub. There's a motion by Representative Nemus, a second by Representative Flannery. All those in favor, please say aye. Aye. Those opposed, no. So the committee sub is adopted, and you may proceed.
Thank you, Mr. Chairman, committee members. House Bill 535 with the committee sub is a cleanup bill to last session's Senate Bill 271, where CJ SAC, the Criminal Justice Statistical Analysis Center, was created as part of the Kentucky Justice and Public Safety Cabinet. In short, Senate Bill 271 went into effect on July 14th, 2022, mandating comprehensive reporting on domestic violence for cabinets and agencies across the criminal justice system. The collected data and analyzed data would go towards targeting services and addressing issues in the areas identified by the data. The following agencies are tasked with the collection of data: the Kentucky State Police, LINK, the Law Information Network of Kentucky, the Cabinet for Health and Family Services, administrative offices of the court, the Division of Kentucky State Medical Examiner's Office, and the Coroner's Office.
Motion on the bill is amended by the sub.
There's a motion by Representative Nemus, a second by Representative Doan to adopt. Is there any discussion? If there's no discussion, would our clerk please call the roll?
I got a question.
Okay, Representative Bratcher.
You know, during this juvenile justice session, there was much discussion that family courts don't speak to juvenile courts. And is this data, and I may be off, Stephanie, but is this data shareable to other court divisions and whatnot? Let me explain. So, like, say a child is in family court, and they come up with treatments or whatnot ordered by the court, and I know that that's non-disclosable, right? But then say that same child is in juvenile court a year later or something on a charge or whatnot, and it's like they're repeating all the treatment over again because nobody knows that the child was under treatment in the family court. Now, I don't know if your bill even addresses this, but I've been wanting to say this all session, that family courts and juvenile courts have a big problem communicating with each other because many of them deal with children. So you're shaking your head, no, this has nothing to do with it, but I'm glad I still said it. So thank you.
And can I respond just briefly?
You can, very briefly.
Just the way family court is set up, juvenile court is part of family court, and that was part of why it was set up that way, one family, one court, so that judges could have access to all of those records so we could do more for families. But I'd be happy to talk to you about
Well, it's not
what that is.
happening. Maybe it's not. Maybe it's just criminal court, a juvenile and criminal court. They're not talking to each other in Louisville, Kentucky, because everybody's complaining about it up there, and nobody seems to have a solution. That's all.
Thank you. So, somebody else, Representative Burke.
I have what I think is a simple question, but just for my edification, the committee sub, I see that there was some language that was stricken and then added in 3B. Will the information about domestic violence, will it all still be provided adequately so we have good statistics and can make good decisions for policy based on that?
Do you want to take that?
Yes, ma'am. All the information that is in here, we will be able to get in one manner. Some of the strikes were like LINK is actually KSP provides that, so it's stricken and moved. And then some of the things that KCDV asked for to be stricken, one was duplicative, and then the other one was not consistent with what they report on the federal side. So it was just for consistency.
Thank you very much.
Thank you. So I think we're ready to call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Brotcher,
Yes.
Representative Bray, Representative Burke,
Yes.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery, Representative Herron, Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson, Chairman Elliott,
Aye. So with 20 yes votes and no votes and no pass votes, House Bill 535 with the committee substitute is passed and should be reported with favorable expression. Congratulations, Representative Dietz. Next, I'm going to take Senate Bill 123, which is Senator Johnny Turner, and he is here. And if you'd come forward, Senator, an act relating to notarial acts. And if you'd introduce yourself, sir, and turn on your microphone, you may proceed.
I'm Senator Johnny Turner from the 29th District that reside in Harlan County, Kentucky. I'll try to be real short. This bill is kind of simple in a sense. It's brought on behalf of the Board of Directors of Kentucky Court Reporter Association. A young lady in my hometown is on that board. From 1982, the governor appointed a special commission. You could be an in-state or out-of-state person to get appointed as a no Republican. You could go in or outside the state. In 2020, with the good old COVID Act, where the governor, nobody wanted anybody to go to Tennessee to come back with the COVID or what, the bill was passed 455 in 2020, did away with the
motion by Representative Flannery, and who was the second? Representative Bray. And so is there any discussion on the bill? And if not, would our secretary please call the roll?
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Brotcher,
Yes.
Representative Bray, Representative Burke,
Yes.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Doan,
Yes.
Representative Flannery,
Yes.
Representative Herron,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson,
Yes.
Chairman Elliott,
Aye. So with 20 yes votes, no votes, and no pass votes, Senate Bill 123 is passed and should be reported with favorable expression. Congratulations, Senator.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee.
Thank you, sir. We will take up next Senate Bill 9, which is an act relating to hazing. Senator Robbie Mills, if you would approach, and I see Representative Dixon and your guests, and introduce yourselves, and then you may begin.
Thank you, Mr. Chairman. Been rushing around a lot of committee meetings. Everybody's doing that today. But thank you for hearing Senate Bill 9. I'm Robbie Mills. I'm State Senator from District 4 in Northwest Kentucky. And I have to my right the Hazelwoods, and I'll let them introduce themselves and represent it.
I'm Tracy Hazelwood.
I'm Kirk Hazelwood.
We're from Henderson, Kentucky.
Jonathan Dixon, Representative, Henderson, Kentucky, District 11.
And there's a substitute, so is there a motion? There's a motion by Representative Nemus. Is there a second? Second by Representative Moser. All those in favor, please say aye. Aye. Those opposed, no. And so the sub is before us, and You may begin.
Thank you, Mr. Chairman, committee members. The House Committee sub that is before you now makes a few clerical changes and direct changes to this legislation. In Section 1 makes note that it is a direct action. In Section 1, it also removes mental. In Section 2, it takes out consent. And in Section 4, it removes the keys portion of this bill. All of these were suggestions along the way to make this a better bill and to get us to the point that we are right now. With that, I will turn it over to Senator Mills.
Thank you, Mr. Chairman. Just a brief. I know you've heard this spoken of in the interim, but we want to just refresh your memory. Currently, Kentucky law places the burden on universities and colleges to enforce acts of hazing with the maximum penalty of expulsion for the student. Senate Bill 9 seeks to add Kentucky to a list of 13 other states that have elevated the act of hazing to a criminal status. For far too long, hazing has been this awkward rite of passage in Kentucky that many still refuse to acknowledge was wrong. We believe the elevation of hazing to a crime addresses head-on the seriousness of these actions. It lets students know that Kentucky values student safety, and violations of their safety will be addressed. And I think that's the most important part of this bill.
Motion on the bill?
There's a motion on the bill by Representative Banta. Is there a second? There's a second by Representative Moser. Is there any discussion? We have two other bills to get to very briefly, so you can
Mr.
be
Chair, I
very
have
brief.
only a short question.
Sure, go ahead.
Thank you. Will this law be equally applicable to people who are under age 18? So if you're a 17-year-old who's in college and you are part of this hazing, are you subject to a felony?
I believe you'll find your answer if you look under the definition of student. It applies to students, so that is under 18. So
Okay,
yes.
thank you.
Yep, thank you. Good question.
Representative Nemus, I think you had a
Thank you,
comment.
Mr. Chairman. I'm assuming this is Lofton's mother and father.
It is.
I want to first of all thank you guys for coming here and for bringing this before us. I also want to make sure you know and the world knows that Senator Mills and Representative Dixon, also Representative Miles, have worked very hard on this bill. At first, I had a number of problems. I know a lot of legislators did, and they were dogged in their pursuit of this to get this done for your son, but for all Kentuckians. So I wanted to thank you for coming, and also make sure that you're aware of the really good work that your representative and your senator has done. Thank you, Mr. Chairman.
And I would echo those comments, and thank you for coming. And I know you've been to Frankfurt a lot, and you were here in the interim, and so thank you for your persistence and for your work on this. So would our secretary please call the roll?
Representative Banta,
Yes.
Representative Lanton, Representative Bratcher,
Yes.
Representative Bray, Representative Burke,
Yes.
Representative Decker, Representative Dietz,
Yes.
Representative Doan,
No.
Representative Flannery, Representative Herron,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox, Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Rawlings,
Yes.
Representative Sharp,
Aye.
Representative Stevenson, Representative Wilson, Chairman Elliott.
Aye. So with 15 yes votes, 1 no vote, and no pass votes, Senate Bill 9 with the House Committee substitute is favorably passed, and same should pass on the floor. So thank you for being here today.
Thank you, Mr. Chairman, committee members.
Thank you very much. So we will next take up, let's see if I can find it on my sheet. Senate Bill 64 for discussion only, an act relating to the Uniform Commercial Code. And that's Senator Whitney Westerfield, who is the chairman of the Senate Judiciary Committee. So welcome to the House Judiciary Committee. It's
Good afternoon,
good to see
Chairman.
you.
Thank you.
You may proceed, and your guest
Thank
would
you,
introduce
Chairman.
himself.
I'm Whitney Westerfield, Senator for the 3rd Senate District and sponsor of Senate Bill 64, which is an act that proposes to update the Uniform Commercial Code. Uniform Commercial Code is the code that governs business transactions in the Commonwealth of Kentucky. And it is woefully out of date. I have with me no stranger to either of the Judiciary committees in the legislature, the Honorable John McGarvey, who is one of Kentucky's uniform law commissioners and was instrumental in drafting this model legislation and working with me to draft the bill that you have. I'll let him speak for himself.
Thank you, Chairman Westerfield. Good afternoon, Chairman Elliott, members of the committee, my representative Petrie, and one of my twin grandchildren's favorite people, Colonel Pam Pam. As Senator Westerfield said, I am one of your uniform law commissioners, so I come to you with no special interest. I work for you. I happen to also be chairman of the Uniform Law Commission's Uniform Commercial Code Committee, so I'm familiar with every page of this multi-page bill and happy to answer your questions. Rather than talk about the bill overall, which, as the title says, the 22 amendments to the Uniform Commercial Code to accommodate emerging technologies. It brings the nation's primary body of business law into the digital world. It does it throughout the code. Unfortunately, a controversy that I think many of you all are aware has arisen really in the last 10 days, growing out of something in South Dakota. The dispute over the amendments really reflects a misunderstanding of commercial law concepts. The cryptocurrency industry was intimately involved in the drafting of this legislation. They support it. The 22 amendments seek to preserve the decentralized nature of Bitcoin and other cryptocurrencies. They enable secured lenders to enjoy the existing benefits of commercial law rules in regard to cryptocurrencies, and they enable people to take them free of encumbrances. The group that I work has drafted a legislative note for legislatures that have been made uncomfortable by some of the comments that have been made recently. I would like to read that briefly to you. I received it today. The change to the definition of money in Article 1 does not exclude Bitcoin or other cryptocurrencies from use in commercial transactions and does not ban Bitcoin or other cryptocurrencies. The definition should not be read in isolation, rather taken together with the definition of money in Article 9, Section 102, electronic money in Article 9, Section 102, and controllable electronic records in Article 12. Bitcoin and other cryptocurrencies receive better commercial law treatment than central bank digital currencies, treatment that respects the decentralized nature of Bitcoin and protects Bitcoin from forced re-centralization through deposit accounts or other custodial accounts used for financial instruments. Adopting these changes together reflects Kentucky's stance against the introduction of a U.S. government-issued central bank digital currency while creating bare minimum rules for those central bank digital currencies that already exist in other countries while simultaneously implementing preferential treatment for Bitcoin. One of the problems we were dealing with is that El Salvador and the Central African Republic declared Bitcoin as legal tender. That brought them under the existing definition of money in the Uniform Commercial Code. That's something we need to clarify as a matter of law, and it's being done throughout the country. The bill that's before you is before the legislatures of 23 states. Alabama is going to be number 24 next week. There's no political agenda here. There's no liberal. There's no conservative. You all probably know my politics from my family. The vice chair of my Uniform Commercial Code Committee, a good friend of mine, is the most conservative guy I've ever met. He makes Jason Nemus look like a liberal, and he teaches law at Texas A&M. I don't want to go on longer than I need to because I know you're rushed today, and I think it's more important that I be able to answer the questions that you all may have regarding this legislation.
Thank you, Mr. McGarvey. And is there any discussion amongst the committee? I thought it was important that we have this discussion.
I appreciate that, Chairman.
Today, at least, so that we're educated on the issue.
Yeah, the bill does the opposite of what people are afraid that it does. It doesn't advance a central bank digital currency at all, and it enables digital currency, cryptocurrencies to exist and to be used in commercial transactions in a way that it can't be utilized through the UCC today.
Let me make one brief point. I say we, that's true, the Uniform Law Commission, and I don't think anybody, when they really think this out, want virtual currency, cryptocurrency, Bitcoin to be money. Because once it becomes legal tender, then all kinds of things set in, like Bank Secrecy Act, currency transaction reports, anytime you deal in more than $10,000, anti-money laundering regulations. What we want is for cryptocurrency to be part of the commercial world. The most important thing about commercial law is being able to categorize the collateral. Right now, Bitcoin's out there in never land because you've got two governments that have said it's legal tender. It could be money. It's more than likely a general intangible. But if you want to use your Bitcoin as collateral for a loan, your secured party has to file a financing statement with the Kentucky Secretary of State. It's going to tell the world you've got Bitcoin. That's not something that the Bitcoin interests want, and what the people who have reacted to this legislation without studying and understanding it have thought.
Thank you, Mr. McGarvey. Is there any discussion amongst members? Representative Maddox.
Senator Westerfield, it's a 166-page bill, and there's a lot of terminology that I would venture to say that most of us don't encounter on a daily basis, a lot of acronyms, and I just had a few questions. I mean, first of which, for those at home that may be trying to follow along, CBDC, that's the first acronym, Central Bank Digital Currency, which of course is a form of digital money that's controlled by the government. But no one that is opposing this bill, as far as I'm aware, would make the assertion that the bill somehow adopts a CBDC. We know that that's a federal issue. That's not what we're saying here. But it appears to create the framework, and this is what we heard in South Dakota as well. It appears to create a framework for the future adoption of a CBDC, and particularly given the definition of money and the exclusion that's found in Section 1 that can only refer to a CBDC is essentially what opponents of this legislation are saying. And my first question would be, was that the intent? And what I've heard you say, gentlemen, it sounds like you're saying that that wasn't the intent of this legislation, yet in South Dakota, where this legislation was vetoed, that was one of the chief concerns. So that would be my first question.
It was not the intent. I won't speak for the Uniform Law Commissioners, but it was not my intent, and I don't aim to do that, and I don't believe that it creates a framework for doing that. That's a federal question that the federal government, I honestly have no idea how Congress, I assume it's congressional, I don't know how they do that, how they would establish a central bank digital currency, or what process is required to do that. I wanted to make sure that we modernize the code so businesses and private entities, even across state lines and so forth, can use cryptocurrency in a way that today they can't. The collateral example that you just heard described, there are steps you'd have to do now that I think run counter to the whole concept behind having a cryptocurrency and using it, that you'd have to abide by. And again, the code doesn't even recognize cryptocurrency today. But there are businesses that use it. That I've seen signs in convenience stores where you can use Bitcoin to pay for things.
Can I have a follow-up, Mr. Chair?
Yes, you may.
And I am hearing in the testimony, if I understood correctly, that you're saying that this doesn't exclude cryptocurrency, Bitcoin, or any other type of digital assets. But my question is this: the Uniform Law Commission has said that Bitcoin and other cryptocurrencies will never be money for UCC purposes. So that, I think, is the issue here, and that the definition would ultimately create an exclusion for cryptocurrencies and digital assets. I think that's why it was vetoed in South Dakota, and I think that that's why a multitude of states are mounting a resistance around the same concept that we've begun to see come up.
You want to respond to that for the commission?
Yes. The Uniform Commercial Code cannot determine what is legal tender. Only the federal government can do that. The issue we were dealing with is that two countries, as I mentioned, El Salvador and the Central African Republic, said Bitcoin is legal tender. That creates a conundrum for anybody dealing with in this country. What we want you to be able to do is if you acquire Bitcoin, that you acquire it under a take-free rule, where there's no security interest that might be attached to that Bitcoin that would take priority to your interest. That rule is created in this legislation. It does not exist today. Bitcoin, if it becomes a controllable electronic record,
Which is a term this bill creates.
yeah, CB, central bank digital currency, appears nowhere in any of the official comments, in any of the statutes. That's not something the Uniform Law Commission deals with. What we do is we set a uniform body of state law to facilitate commerce amongst the states. To give you an example, if somebody from Henderson was just up, if they go across the river to Indiana to buy a car and finance it there, the Uniform Commercial Code sets the rules for using that car as collateral in an interstate transaction. But the Uniform Commercial Code doesn't regulate the registration of that motor vehicle. It doesn't regulate the use of that motor vehicle. All we do is provide rules of commerce to facilitate commerce, which is really the reason for being of the code. And what we're trying to do with this legislation is to make cryptocurrencies, Bitcoin, if you will, which is a cryptocurrency, more commercially viable. Not declaring it money, we believe, is in the interest of the industry, and the industry reps that participate in drafting this legislation agreed with that also, because as I indicated, once it becomes money, it is less viable in terms of use of collateral. The only way you can perfect a security interest in money is to possess it. If it becomes the cash equivalent, as I indicated, there are going to be all sorts of reporting rules regarding people who own it, and they seek more confidentiality than that. We think this preserves the best of all worlds for cryptocurrency and recognizes it as a medium of exchange in the modern economy.
One more follow-up?
Thank
or
you.
are we
Yeah,
done?
very briefly, because
Yes.
I want to
Yep,
reserve some time for
absolutely.
Senator Yates to be able to discuss his bill. So
No,
go ahead.
I appreciate the dialogue. I think that it is fair to say that stakeholders within the cryptocurrency community are not in favor of this legislation. That said, the language of the definition of money in Section 1 clearly states that any existing cryptocurrency, Bitcoin, so forth, so on, cannot be considered money under the UCC. So while I understand that you're saying that that is a federal issue, it is a federal issue. The way that we are codifying this language, if we were to pass this in Kentucky, is excluding it.
That solves the El Salvador and the Central African Republic issue. That's the only reason that's there.
I find it personally problematic. I'm glad we've had this discussion, but I think that this is an issue. Very
There are
serious
two
issue.
central bank issued digital currencies in the world right now. One of them is the Bahamian sand dollar. That's actually the term for it. The other one comes from one of the Pacific Islands, and I can't remember which one it is.
Thank you, gentlemen. We appreciate your time today, and thank you for educating us on this issue. We are next going to take up Senate Bill 268 for discussion only. Senator David Yates is with us, and this is an act relating to child support after driving under the influence. So you may introduce yourself and begin. I know we heard about this topic in the interim on this committee, and so we're looking forward to your presentation. Thank you.
Mr. Chair, ladies and gentlemen of the committee. I'm Senator David Yates of Jefferson 37. First of all, thank you for being here. I know time's running out. I'll try to be quick and short. This is something that's very personal to me, and I think a very important piece of legislation. It allows for restitution, and I know it can be confusing sometimes because we use the child support, but it's restitution in the form of child support after a DUI conviction if the parent or guardian has been killed because as a result of the DUI or permanently disabled. I named it after Melanie, who's my cousin, who likely won't, she's fighting for her life right now. I've been practicing law for about 17 years. We see this a lot into it as far as drunk drivers hitting people, doing a short bit, and then children sometimes living without that parent and the ability. Mothers Against Drunk Drivers just sent the letter of support. This has happened in other places such as Tennessee. It can be confusing as a practitioner. Sometimes when I see the word child support, it scares me. I run away from it. The way they get around this is that this is restitution in the form of child support. They use the guidelines of child support, and the county attorney's office is even willing to help with the collection of that, but it's separate and apart. And the reason that's important is, well, first of all, several reasons it's important. Civil penalties don't hold. You hit somebody, if you have insurance at all or minimum coverage of $25,000, it's paid out, it's done. You serve your 3 years, 2 years, whatever that is, and you get out, you go on with your life. This child has lost their parent or guardian forever. So whether or not, even if it's small amounts of money that's paid out, that's a check they're writing. And I know that the reason you have to look at for instructions on how to order that restitution, you look at those guidelines for fairness and the idea. No different than a personal injury action. I argue that someone's been disabled from an accident. I'm not bringing something through disability court, but I'm arguing, sometimes I use some kind of guidelines and ideas. This has worked in other places. It works here in several ways. First of all, for fairness for that child. Think about the orphan child. Think about the child that the primary breadwinner has been taken away. It also works as a deterrent effect. It's a discussion. People are talking about this. It matters. But ultimately, to me, it's more important than that. It's too often when I have a client, now a family member, who have a surviving child, we can give some kind of remedy, and we can do that here today. Again, it's put into fairness. If they have 6 children into it and they have no means to pay, they get out, and of course the restitution would be ordered to begin after they had a year out. Then all that's taken into consideration, which is fair and reasonable. So I'd ask that we pass that if we can. I know that a special committee meeting is possible. Time is of the essence. We got the letter today. I know there's a lot of victims who would benefit by our quick action. I know our delay means there's a lot of people that lose in that loophole, that interim. So I think we have 11 members here today on the 21. I'm not great at math. We had just enough if it be the rule of the chair. But I really appreciate you guys taking the time to hear me, and whatever can be done to move this forward.
Thank you, Senator. Representative Dietz, you're recognized.
Yes, thank you. I appreciate this bill in theory. So my questions really have to do with how would you calculate that support? Would you reference them back to the child support statute so that they are using those same guidelines?
So in the bill, and I personal injury lawyer into it, and I think practitioner. So what I did is enlisted the help of professionals, and I think that there had been, in Tennessee, I think there may have been some budding with some of the federal things. So that's why they're all guidelines they put into place, and they do it in the form of restitution but use the child support guidelines as a reference. Obviously, it would be determined by, the determination would be by the sentencing judge, obviously. And so different than they took catalytic converters and you have to pay restitution for that. They can make that decision, based on what it would be. But you use the guidelines just like you would with child support. And the reason they did that is because ultimately that's kind of found a fairness. It's not a system that's put into, it's a hard system because it lays down with the sentencing judge that shall issue restitution in the form of child support and using these guidelines as factors.
Can I ask a follow-up? Yes.
Go ahead.
So, and maybe I just don't see it.
Okay.
Where in here do you reference them back to using our tables? So I was wondering, would you not add in there for them to use KRS 403, which I think is the child support statute, so that they're looking at incomes of the parties, and then would we also then make the defendant the non-custodial parent in the child support worksheet? Is that what you're trying to say, or am I just completely missing it?
No, Representative, thank you for the question. I think that a couple of the child support practitioners, that they wanted to put it in like child support guidelines. And I think because you talk about restitution in the form of child support, we're thinking that, just like in my example of in a personal injury action, I'm saying disabled, it's not necessarily like disability court. So what we did on the second page, page 2, under subsection B, we looked at that the court shall determine an amount that is reasonable and necessary for the maintenance of the victim child or dependent after consideration of all relevant factors, including. So what we did is we didn't take away that discretion from the sentencing judge onto it. We added out factors that we want to, but I think if we actually put this in the child support guidelines into it, you get into some gray area with some federal regs and other things like that. So we stayed away from that. And the reason we did that is it's already been tried, it's already worked in another place, and I wanted to make sure we had a 7-iron down the middle. That when a sentencing judge is ordering restitution into it, they get to see everything. They get to make a determination what's fair and what's reasonable onto it. And again, I know that probably be less money for some of these children. But I felt like I wanted to make sure we didn't run into problems. And the biggest part, not the biggest part, a big part of this is when they're out, they're still writing that check for this child, the surviving child. And sometimes it may be small. If they don't have a lot, if their job is making very little money, but it's got to be something. What breaks my heart more than a lot of things is I get minimum recovery because we have very low limits here. And then I got a kid who is 18 years old without a parent, who has nothing, who accumulates debt. And then I have the person who took the life of their parent, who's driving nice vehicles, moving on with their life, doing whatnot. And there's got to be some type of justice and accountability, and that's what I'm asking us to do here today.
No, go ahead.
I just
Go
have
ahead.
one last one.
Very brief.
With the wording, then maybe I'm hung up on the wording. When you say child support, to me that's child support under the statute. What about support of the child in terms of restitution? Maybe I'm getting hung up on the wording.
And I think that was some of the discussion, and I started off that way, the same way, and it was because it says restitution in the form of child support. So I guess we could call it restitution in the form of supporting the child. But I think, and I guess probably what we do, but in my definition, we lay out the reasons what it is. And I think even when we say child support, we have to reference the statute to get into those perimeters.
Right.
That's not what we do. It's just my explanation of the bill, because I want to know the fairness and the reason and the justice of the restitution is not punitive at all. The restitution is to pay for the lack of support that child would have received.
Okay, thank you.
Thank you. And you mentioned that you had looked at another state. Which state is that, Senator?
Tennessee.
Okay.
And that's when I looked at, because we keep using it for examples and other things here. Mothers Against Drunk Drivers have talked about, they've named some other laws where they've been supportive if it's gone into place. And they've been helpful with this as well. And I want to say thank for their expertise in doing this as well.
Well, thank you. Thank you for your time, Senator, and we appreciate your patience.
Thank you, guys.
Today. I can't read that. Okay. And so we thank you very much. Representative Blanton, I believe you'd like to record a vote.
Yes, on Senate Bill 9, I'd like to record an aye vote, please.
Yes, sir. That is recorded. So does anyone else need to record a vote? Representative Moser.
Yes, thank you, Mr. Chairman. I would like to record a yes vote on Senate Bill 40, please.
It's recorded.
Thank you.
And Representative Decker, I believe you'd like to record a yes vote, or a vote, I'm sorry. And that's a yes?
I'm sorry. Senate Bill 9?
I think I recorded that. 40 is a no.
Okay, so Senate Bill 40 is a no. Did you get Senate Bill 123, Senator Turner's? Okay. Senate Bill 199?
Did you have 204?
Yes.
Or she did?
Did you vote on that, or is that a yes vote? Okay. And Senate Bill 203, President Stivers?
Thank you. And if there's no other